Is it?
And
Yes,
thank you.
great.
It is now. Thank you very much, Mark. And for most of you know me already, my name is Lisa Coates. This session, I'm the plenary coordinator for the LLB. And again, thank you very much to all the elders who have taken the time this morning to join us. It's my great pleasure to introduce Justice Musgrave, who has joined us this morning. And by way of introduction, Judge Penny Musgrave is originally from Armidale, so another regional lawyer. She went to Sydney to study law, having never known a lawyer and never having set foot in a courtroom. And since then, she's had a varied career, which she never anticipated when she combined law as her first uni choice. She has had more than 36 years experience in a range of legal settings, including the New South Wales and Commonwealth public sectors. For those of you students who are sitting in the room with us who are currently studying criminal law and criminal procedure, you might be very interested in having read her bio that she obtained her law degree from the University of New South Wales in 1985, but she also has had experience in both private practice, but also predominantly as a prosecutor at the Commonwealth DPP from 1989 to 2008, and has worked with the Department of Justice and was the director of the Criminal Law Review from 2008 to 2015. She has also operated her own practice, primarily practicing in criminal law and representing notable clients until 2022, when she was appointed a judge of the District Court. And most notably, she was the first solicitor to be appointed to the bench last year. In 10 years, the majority of the judges have been having been appointed having been called to the bar first, and I'll be asking her about that today. Good morning, Justice Musgrave, and a warm welcome to you.
Morning, Lisa. I hope you can hear me okay.
We can hear you loud and clear.
Good.
Thank
Lisa,
you for joining us.
Thank you. Lisa, can I just say before we start, first, that I'm also zooming in from Wiradjuri land and do want to say it is an absolutely amazing day here today. But I just wanted to thank the elders for the contribution earlier and say that I really hope that I can take up the invitation they extended to learn some more about the Wiradjuri people out there. It has been an extraordinary privilege to come up and work out here. And I just found that session really positive, and I hope to take up the opportunity.
Well, I invite them to respond to that if they'd like to. I certainly wouldn't presume to speak on their behalf. So, Yandara will...
Come on down. Yep.
There we go.
I'll have a cuppa and we'll show you around.
I'll be in Bathurst from next week for 4 weeks, so hopefully we can catch up.
Definitely, yes.
Well,
terrific.
Our door at CSU is always open, so I'm more than happy to do what I can, and so we'll mark at our end to facilitate that. So, but we're happy to put the two of you in direct contact with each other if you would like that. So that would be marvelous, Judge. So brilliant after this session. I have sent Justice Musgrave a number of Q&A questions, because in terms of getting to know her, really, Your Honour, you grew up in Armidale, New South Wales, which is, as I said in our introduction, a similar rural and regional area to many of our students. Our students hail from all over Australia. We have some internationally, but CSU tends to attract students that are rural and regionally centred, and particularly for this law degree, and very similar to us on the Bathurst, New South Wales campus. What made you tick combined law as your first university choice?
I have to say, given the theme of today, that it was a complete and utter lack of research. I absolutely had no idea what I was doing. I was driven by an ATAR, or I can't even remember what it was called back then. And for me, to be completely frank, it was a way to leave Armidale. It had nothing to do with being a lawyer. So
Okay.
I really went in with it being a completely blank slate. I didn't go in with any desire to be any particular sort of lawyer. For me, it was a way of leaving a university town. It was the one degree that Armidale didn't offer, and it was my route out. So it's been a very interesting experience for me to come back to a rural area after having spent so long in the city. And I think we can probably talk about that later. But yes, it's probably not the best foot to start on, but yes, a complete and utter lack of research or knowledge about what the law was.
But I think it was quite a common thing, certainly for a number of generations of, if I can call us, country kids leaving and going off to the city to find their future. And certainly CSU have been very big on trying to reverse that trend in trying to, not just kids, in terms of young adults, trying to keep young talent in the rural and regional areas. Certainly with our law degree, our engineering degree, and our recent launch of our partnership with medicine, we're aiming very much to try and keep regional talent in the regions.
And look, and part of the issue with leaving for me back then was the isolation, because Armidale back then was, I think, 10 hours on the train. It was a long way away. It's not like that now. And the sense I get is that isolation has evaporated. So there is much more connection with colleagues and everybody else these days. But for me, it was getting away from that feeling that you were so far from anything. You were far away from what was happening. And I don't think you can say that quite as much now about rural or regional life. It's still different, but you can still access what's happening in the hubs a lot more easily.
Yeah, I think it's a really key point when you're talking about that connection to how we've moved on and how we've diversified in terms of it, and also with technology and change.
Exactly.
Many of our CSU students and faculty, including myself, are first in their family or close community to study law. What did you find were the unique opportunities and challenges that came with being the first?
Look, I think part of the challenge was not knowing what the opportunities were. So as I said, I went into law not really knowing the range of things you could possibly do. I didn't go in with a burning desire to do something, but I also didn't know what I could do. So that did mean that you needed to dip your toe in and go to different places and work out what it was you loved, what it was you wanted to do. So that was a slower process for me. I didn't have the network that a lot of people did have. Having said that, though, I think that ignorance, for want of a better word, was a positive, because you tend to go into things with a very open mind. You're non-judgmental. You haven't formed an opinion. So you really, and it's something you carry with you throughout your career, an openness about what is out there, taking things at face value, exploring and being open for new opportunities, more so, I think, than someone who comes to law with a preconceived idea or a preconceived structure around them. I think their life in the law might be quite narrow. I think if you're new to, if you're the first in family, or you don't have that preconception, it's this whole world that's open to you. And that's a massive positive.
Well, hopefully it might be also an advantage. And there's been a big movement, at least in the past 10 years, about this concept of new law, doing doing legal practice differently, the deconstruction of the big law firm and the traditional idea of doing law, smaller firms, sole practitioners and that sort of thing. And some of what you're speaking to now seems to speak to that sort of attitude, being more open-minded,
Yes.
being more dynamic in approach, and perhaps those students that come from that background might be more advantaged in that sense.
And also an ability to create new networks. So if you're working in different ways, creating networks that might inform you about how you work in a different way, or allowing you to work in a different way because you're falling back on people in a new way. Oh, my screen just went black. Hopefully that's not an issue.
That's okay. Well, I can still hear you. We're all still here with you.
Good. So yes, I think all those things we spoke about are an advantage that you have coming into it if you don't have that background.
Now, you went to University of New South Wales at a time, which is an excellent university, but you went at a time, and cast your mind back to when the study of law and research of law, and I'm reticent to kind of when I say cast your mind back, it was a great time to go to university.
It was.
When the study of law and research, it's a fabulous period of time, and research of law, which is the topic for today. So I'm going to keep kind of orbiting around that. Had a very different approach to what we do now, both in study and practice. So I went to, both Mark Nolan and I went to the Australian National University. We went at different times. We weren't kind of, sitting in the library next to each other, but we both went at a time where you had to pull the books out and look at the folios and look at, the loose leaves being updated. Could you describe for us your experiences of the study of law at university?
Well, mine was very much like that. I mean, I can recall having to look up articles in a digest that came out. I think that's what it was called. It was a book that was at the front of the library. You'd have to go up and look and see what articles had been produced. Computers just didn't exist. We had to be there in person. There was no option. It was an exciting time because I think back then UNSW was one of the 3 institutions teaching law, and it was teaching in a new way. So we had small classes, but you couldn't dial in. You had to physically be there, which limited the accessibility of the courses, absolutely. But I think one of the most glaring examples of how reliant we were on hands-on research was when I first started work at the Commonwealth DPP, and the librarian there used to get the print of legislation, and when there was an amendment, someone would have to cut it out with scissors and glue it on top of the existing section, because the government printer only did the reprints every couple of years. So you'd fight to get that copy of the legislation with the glued in piece of paper on top. When I was at UNSW, there was, in its infancy, a course about computers and the law. And I remember we had to go to the library and use the computers. And I got stuck in the library at night because I couldn't work out how to turn it off, and had to call the lecturer at home because no one could help me with turning off this thing. That's how long ago it was. And yeah, it was very different.
It was very different, but in terms of how did that, I think that's, going through those experiences of what I call arms and legs research, of, having to do the physicality of going and looking and searching and finding, really kind of having to Sherlock Holmes a lot of the law. How did that affect your approach and your attitude towards research now?
Look, I think it gave me I don't think it affects how you research necessarily, though obviously it's changed a lot because we now use technology to do research. I think it informed what is critical to being a strong researcher, which is the organisation of your research. Because back then we didn't have a computer. We couldn't Control F. We couldn't Google something. You couldn't repeatedly do something. You found something and you needed to write notes about it. You couldn't cut and paste it and keep it in a document. the photocopier was a limited resource. I know it sounds ridiculous. It's actually hard to conceptualise just how different it was. But you had to take handwritten notes from a case. The cases that you had access to were the ones in the textbook. And what that meant was you needed to extract the critical information, you needed to organise it in an accessible way and in a way that you could update it. So what it honed was the management of information that then informs the presentation of research. So you've got the physical or the base research, then the organisation of what you draw out of that research and the presentation of that research. And I think I still use those organisation skills today.
Yeah. Yeah. And thank you very much for that, because I certainly find there are some similar takeaways in colleagues of, that I know that from the bar that have spoken about similar types of experiences that they've drawn from their, their earlier days of learning and practicing. So it's interesting to note the similarities. You had a career as a prosecutor at the Commonwealth DPP. What was some of the most memorable work in that chapter? Because we've got some students that, in this space, and also that will be listening back on the recording. The wonderful thing about our law students is some of them are already working as paralegals, some of them are working have had long careers as everything from town planners to public servants and so they will be very, very excited to hear this.
Yeah. Look, I was extraordinarily lucky to be at the Commonwealth DPP at the time I was, and anyone who was there with me acknowledges that. It is called the golden years of being there. It had been in existence for about 3 years when I arrived, and everything about it was new. The law we were doing was new. The way we did it was new. We'd actually have situations where we were running a matter, and it was a situation where there was no interpretation of the provisions. There was nothing to fall back on as to how it would be approached. We were doing some of the most complex cases that had hit the courts in New South Wales, because all of a sudden taxation fraud, big taxation fraud was happening. And I started there at the end of the bottom of the harbour prosecutions, which probably so long ago no one even remembers it. But that was really the end of a series of prosecutions that involved massive amounts of documentation, and it had really never been done before. And people would send around a message by sticking an A4 sheet of paper on the back of the door so everyone would see it when they went out, because there was no email saying meet in the lunchroom. I need to talk about how to draft a search warrant because I'm worried about this provision. And we would actually get together and talk about how to do it. And I was working with some simply amazing creative people. So that it was a really, really exciting time. And so I very quickly went into the major fraud section there and really mopped up the last of the bottom of the harbour prosecutions, which was also the start of the development of white collar fraud principles in New South Wales, which have over the 20, 30 years have evolved massively, and we won't go into reports of the Gibbs Committee and all sorts of things like that. But what that whole period impressed on me was just how organic the law is. It's a really interesting thing to reflect on it. People see law as a static, conventional, traditional, highly structured discipline. But it's actually, that superstructure might be, but it's actually evolving all the time. And so when I look back on my early days of the Commonwealth, what the law was back then and when I was at university is completely different to what it is now. So memorable cases when I was at the Commonwealth DPP. Look, the thing about criminal law is constantly, it never ceases to amaze you what people can do. So a lot of cases were really, really interesting. But I did a year-long trial involving a taxation fraud. I did a fair bit of extradition. Someone who had kidnapped someone and sent their ear to the Pope and various other things like that.
Oh gosh.
Yeah, I know.
It's dramatic.
Oh, look, he had kidnapped a person in Italy, been arrested, was on weekend detention, escaped, was chased down a motorway, shot a police officer with a Kalashnikov, got on a plane to Australia, got arrested at the airport for having more than $10,000 in cash in his bag, gets taken into custody for that. They work out who he was. He gets arrested, and then the extradition warrant kicks in. So I did the extradition warrant, but they'd managed to capture him because he wasn't in custody, because he'd run out of the old St James Court, which used to be above David Jones, and didn't realise there were glass sliding doors. So he ran straight into those and broke his nose. But they're the sorts of fascinating matters that are always around the corner when you're a criminal lawyer. But yes, at Commonwealth DPP, I mainly did white-collar tax fraud and major drug importation, so very large imports. And that was the bread and butter of the Commonwealth DPP for a very long time, and still is.
And it's just extraordinary. And we have, we've had I'm not sure whether or not you would like to address this, Your Honour. I was going to suggest that we look at questions towards the end, but we have had a comment in our chat box that one of the somebody's suggested that the bottom of the harbour is still alive and thriving. So I'm not quite sure whether or not you would like to address that or let that go through to the keeper, because it's a cryptic comment that we've had in the chat box.
The issues around bottom of the harbour still exist because, let's face it, people's imagination about how to minimise or avoid that taxation are never going to go away. The industry that was targeted by the bottom of the harbour Royal Commission and the subsequent prosecutions might have been resolved back then, but absolutely the need to respond to that sort of behaviour has not faded. I mean, I can talk at some length about the shifting complexities of prosecuting those matters, which is really, I find that a particularly interesting area because the very, very long trial of the Plutus payroll scheme has just really come to an end in the Supreme Court with the people being sentenced in that. And I've got some personal familiarity with that one, but what technology has done in recent years is created these massive, massive prosecution cases. And not surprisingly, that trial took over a year to come to an end. And that's a fresh issue that has to be looked at and is going to need further work to ensure that the system isn't crippled by the volume of information that is now available in a prosecution.
And as I said, I'm going to continuously bring this back to the orbit of research, and I thank you for addressing that. And on behalf of Preco, who addressed that in the chat box, the time of the Commonwealth DPP was from 1989 to 2008. This did cross over with some really seismic change in terms of technological development. When we look at the advent of the internet and the movement of communication and resourcing online, can you describe how those changes impacted upon the Commonwealth DPP?
On a whole lot of different levels. I think in terms of actually day-to-day communications with colleagues and people you're working with, the impact was less significant. Even when it came to international counterparts, you would still have investigators flying out to see you. You would still do a mutual assistance request or an extradition request in the same way. I think the major impact has been in the investigation and management of the prosecution because of that volume of material side of things, because there is just so much more information available. And it also affected what skill set you needed to have in order to manage it in terms of understanding it. But it also goes back to what I was talking about before, is using those research techniques that you had and those organisation skills, because all of a sudden, rather than finding a folder, a physical folder in a house, you were finding a hard drive that had a house full of documents, and you needed to be able to use your research skills to get across that, to find what was relevant and to organise it at your fingertips, and to then work out how to use it when you're presenting it in a way that means it is accessible, instantly accessible. And that really, the impact of technology has largely been in the volume of material that is available as a prosecutor.
And I would imagine that impacts on things like workloads and staffing and, also the human factor as well.
Well, it should, but it didn't, in the sense that that's relatively static.
Yeah. After your time at the Commonwealth DPP, you were Director of the Criminal Law Review at the Department of Justice. Could you please tell our students a little bit more about what the Criminal Law Review does at the Department of Justice and the importance of their role?
Unfortunately, it's past tense because Criminal Law Review no longer exists. And this is not the platform to speak about that. But what it did back then was, it was a very small group. It was about 8 of us, who the majority of which had a practical background. So it was very, very different in terms of government policy development. It's one of the few instances where you have practitioners, specifically experienced practitioners in that area, coming in and doing policy. We were the principal advisors to the Attorney General and to the Premier, and so we were responsible for all of the Attorney's criminal law proposals and the passage of legislation, but we also commented on anything that had a criminal angle across the entire government portfolio. And if New South Wales had a comment on a Commonwealth proposal, we'd advise on that. So if health or fair trading or someone else had something that had a criminal element, was introducing an offence or something like that, it would come to us and it would have to pass my desk before it went through to Cabinet. We would be responsible for all consultation, development of Cabinet minutes, briefing ministers, drafting legislation with Parliamentary Council. We'd be responsible for the passage of the bill through Parliament. We'd go and sit in Parliament. We'd draft the second readers, Q&A, Dixes. And I didn't go to Parliament every night. Whoever was responsible for that bill would go, but I would basically have the computer running at home. So I would be there we'd be there till 11 a.m, 2 a.m, whatever time the debate finished. And then usually my phone would start in the morning because the media cycle meant that the attorney would be answering questions at 6:30 or 7:30. So I would be on call. So that's what we did.
Yeah. It sounds very intensive, and
it was extraordinary.
Yes, as part of my, preparation for today, I, of course, did my research on each of my guest speakers, and I noted that, you know, during your time as director, you were a member of the New South Wales Sentencing Council and the Model Criminal Code Officers Committee and the DNA Review Council, review panel, I should say. And I'd like to address each of those in turn, if that's all right. The New South Wales Sentencing Council is made up of 16 members currently, which include judges, prosecutors, and criminal defence lawyers, victims advocates, and police, as well as community representatives. It's as an independent advisory body, so it's quite dynamic in that sense of wanting to be quite representative across the board. Could you tell us a little bit about the research and advisory work for the Attorney General that you were part of during your time on the New South Wales Sentencing Council?
The sentencing, essentially it's a standing consultation body that advises the attorney, and it was very active when I was a member, and produced some fantastic reports, which I actually had a look the other day, and they are all still up online, and it's a great resource because it's an amazing.
You've gone on. You're on mute.
Back.
Your Honor.
I think I'm back. I think I'm back.
That's right. You're back.
Sorry.
Yes, you are back.
Entirely my screen. Lost my train of thought.
That's all right.
Oh, yeah, no, I did have a look the other day, and the reports are online, and they are a great resource in order to understand some of the policy that sits behind some of the existing legislation. So things like high-risk offenders,
yes,
the not so much sex offences because that's moved on a little bit, but you can there's amazing resources to look at the comparative research and to get an understanding of the dialogue that precedes legislative change. Intensive correction orders, which was the first bill I think I had to put through. I wasn't on Sentencing Council when it was developed, but going back and looking, that report gives you some insight into the early changes in thinking around the shift in sentencing law. The research component of Sentencing Council back then was with one person who performed the secretariat function for the council, who at that time was Kath McFarlane, who then ended up at Charles Sturt for quite a while. And she was an amazing, incredibly enthusiastic researcher who just had this network of people that she called on. So you had a situation where you had a skilled researcher pulling briefing materials together, but then the input from everyone on the council. And because it was a standing consultation committee, relationships developed and a degree of confidence around the table. So although you've got a diverse panel with lay people and professionals, there was a concerted effort to give everybody an opportunity to be heard and to speak. So it really encouraged proposals that had the input from all those sectors, which was the reason behind it. I mean, it's got a legislative framework. It's actually embedded in the legislation that all those representatives must be there. So there was some tough work that Sentencing Council did that was the subject of a lot of debate, and they weren't always unanimous reports. There were majority reports during the time around things like extending high-risk offender legislation. But I mean, I'm forever grateful to have had the opportunity to be around the table to gain that understanding of what informs a lot of the legislation that I'm now applying. So it's very interesting.
It's given you a brilliant background for what you're doing now. And at the same time, you were also working on the model, you were on the Model Criminal Code Officers Committee, which brings me neatly to a question that Professor Nolan's asked in the chat box. So I might actually invite him to address that in his own voice if he'd like to.
We've had an earlier session together, haven't we, Judge Musgrave?
Yes.
As federal criminal law, excited federal criminal lawyers. When you did that work, what was your perspective on academic researchers coming together with legal practitioners? Is that really essential type of partnership to do something as complicated as drafting a new codified federal criminal law?
It's a tough question to answer. The contribution of academics on the development of the model criminal code was huge. Ian Leder Elliott had an incredible role to play in that document.
Professor at University of Adelaide, for those
yes,
who
that's right. That's
don't
right.
know of him yet.
South Australia were very active participants in the development of the original code. And yes, academics are an incredibly valuable resource because they do bring a different perspective, and they do have that capacity to have a more holistic view of what's happening as well. And I also had some involvement in the Institute of Criminology at another institution that I won't mention. And it was in that role that I felt that academics weren't taking the opportunity to be as involved in the development of policy as they could. The system, or the habit we've got into now, is something comes out and there's a critique from academia. So there might be reforms to bail law, and you'll find that 6 months down the track, there'll be a journal come out that focuses on bail reform. When really what is desperately needed in New South Wales is front-footing that research and saying, these are the issues. Why isn't change happening? Because practitioners are absolutely smashed with work. The public service are incredibly busy. Policy resources have diminished. They are doing what they have to do. They're doing the essentials to get something done. And if academics can actually pull research together and say, here's a social need that needs to be addressed, and there might be a novel way of addressing it, there's such an amazing resource in identifying something also in a different way, a real solution-driven way. Anyway, that's my little lecture on what I think would be wonderful. And I suppose the code is an example of it. South Australia was deeply committed to the accessibility and the simplicity and the efficiency embodied in a code, and they were committed to what was then a novel solution and put all that work into it. So yeah, academics could really do something. Be great.
That would be great. The reward for good work, I hope, is more work. Judge, the final question is actually from our next guest speaker. So in the spirit of collegiality, and I hope we're modeling this in our legal profession as we do, we've got in the space here Mr. Russell Kavanagh, who is a Darug man from the Port Macquarie area, and he is also one of our sessional lecturers. I'm going to introduce him properly for the next session, but just to introduce you to each other, he works for Legal Aid, and he will be in a Q&A session for our next session. And he works in 3 divisions of crime, civil and family law with Legal Aid. He's actually popped a question in. This is Russell Kavanagh. He's asked a question in the chat box that technology is significant in today's society and undoubtedly will advance into the future. How will you see the courts are going to keep up with the acceleration of technology into the future? Russell, would you like to pop on your microphone and say hello to Justice Musgrave? I'd love to introduce you to each other.
Good morning, Justice Musgrave. How are you?
Hi, Russell. Lovely to meet you over Zoom.
Yes, exactly. Technology in the working.
Yeah.
So I have in the past, I had the opportunity to sit on the bench with Judge Slattery, and this was one of the issues that came up in a matter that was actually in the Supreme Court, that technology is accelerating at the rate of knots. We're seeing more and more, for instance, people seeing that it's going to be something that they can hide things. How do you think the courts are going to deal with this into the future?
Yeah, look, there are so many layers to that question, Russell. I think we could probably talk about it for a day at least. The court itself is going to be able to cope, accepting all the difficulties with technical connections in a courtroom. But AVL is there. It's simply the theatre. It's simply the room in which something takes place. You've really got the issue again back with the practitioners, and it actually does tie in with the theme of today, which is research, and what I say is the critical part of research, which is organising research, which is the skills of the investigators and the practitioners to understand how to use the information that is being pulled as evidence, usually, from that technological bucket, and present it in a way that is usable. I mean, a really good example is, Cellbright's downloads of mobile phones. And when I sit in court, I see some practitioners who understand it and can use it in an extraordinarily powerful way. Like those reports are incredible. You can, I'll go back to what I was talking about so you'll have someone who can use it in an incredibly amazing way, and then someone who is struggling to get past a piece of paper and might just have printouts of photos or something. And that's a perfect example of understanding what it is you're working with and committing that time to understanding it and doing that research. Because if you are completely across that photo has all that data sitting in behind it, and there is someone out there in the community who gets it, and there's someone out there who gets it who can explain it to you. And I can say, because I've done a lot of work with these sorts of things, and most people will look at me and go, you are too old, you're not going to understand this. But I know that I don't understand it. So I'll pick up the phone and actually find someone and go, talk to me. And I should say this not on the bench, because I'm in a different position now and I can't pick up the phone and ask that question. But when I was a practitioner, I would actually find someone, even if it meant calling a colleague and going, do you know someone, do you know someone, do you know someone? Might take 5 phone calls. Find someone who'll sit down and go, this is the metadata that's sitting behind that printout. You've got a text call that says hashtag, hashtag, hashtag. That's actually because they're using this software and it means this, and this metadata sits behind it. And if you issue a subpoena to this agency, that section's going to require them to produce that metadata. Really annoys the prosecutors when you do that, but it's really effective. Yeah.
Yes, I can imagine it would be. Yeah.
But look, do you know, Russell, I really think it comes down to one thing I did want to say today, which is, as lawyers, we never, ever, ever can stop learning. And that's what is so amazing about this profession. I think what keeps people going for so long. And if you ever think that you don't need to know anything more, there's something wrong with the way you're practicing. And technology is a really good example. And it's not just about using your computer. It's about continuously learning and talking to people and researching and using it, because you can't be overcome, but you can't be overwhelmed by it. You'll be lost.
Yes, I couldn't. Yeah, it's just that technology is it's just moving so fast. From when I went to school, we used slide rulers, and that was that was all good. And the little sharp calculators. Now it's just a totally different world. And I see particularly in the world that I work in, particularly right now, is that technology is becoming so fast and so different, and different people use it. As you say, some people use it quite well. Others fumble with it. But do you think that this is going to be something that will go hand in hand with doing a law degree, that maybe more technology understanding needs to be within there?
No, I don't. From my perspective, the impact of technology is really on evidence in criminal cases. So, crime is my experience, but it's how people use technology as opposed to it having a direct impact on how we work at the moment. Now, having said that, there might be changes in the theatre, which is a courtroom, and there's another institution that's doing a lot of work around technology and courtrooms and virtual appearances that have got some interesting sort of policy questions around that. But that's very mechanical.
Okay.
I think the challenge when it comes to technology is around people communicating in a different way, and the volume and the impact from an evidentiary perspective, and the impact it might have on police powers. And that is a very interesting area about, as particularly in a jurisdiction that is quite open to coercive powers and significant coercive powers. So that to me is the pressing issue arising from technology.
Thanks, Judge. Thanks very much.
Good to meet you.
Good to meet you too.
There's and it's all on point when we're talking about the benefits and advantages of technology. I just want to take the opportunity to thank Her Honour for taking the time out on a Saturday morning. It's as I always say to every guest speaker, it's a big ask at the end of a week, and it shows her dedication to, as she said, continuous and lifelong learning, and she's modelling that in a very big way for our students, as well as her commitment to our university. So could we please express our thanks to her, whether it's through the chat box or through a thumbs up or a clap of hands, to Justice Musgrave. We really deeply appreciate your time with us, and we will certainly take you up on your offer to continue the conversation when you are in Bathurst over the next few weeks. We warmly welcome you.
Oh, thanks so much, Lisa. And yeah, rural and regional is no longer isolated, and there is some amazingly interesting work and a lot of work to be done out here. I think there's an amazing opportunity for people who've got a rural background or a regional background to really make a difference if they want to commit to a profession in this area. That's my plug. So thanks so much for the opportunity to join you this morning, and I hope everything goes really well today.
And there's plenty of love there in the chat for you. Thank you for being inspiring and helping our students today, from a number of the students there. So thank you very much.
Thanks. I'll sign off.
Thank you.
And we'll
just
stop that
pause.
recording.
I'll just
stop it.
Yeah, we'll
just
stop.
completely stop it. Yeah.